call this meeting to order of the Planning and Zoning Commission. Today's April the 4th, 2019. First item that we have is, can we have a roll call, please?
Yes, Mr. Chairman. Erasmo Guerrero,
Present.
Jose Perez,
Present.
Jorge Dominguez, Abraham Lugo,
Present.
Johnny Narvaez, Raúl Ugalde, George Beckelhammer,
Present.
Carlos Flores.
Present.
For the record, Mr. Chairman, you do have quorum.
Thank you. I did get communications from Mr. Dominguez and Mr. Narvaez. If you could please excuse them.
So moved. Second.
Motion is second. All those in favor?
Aye.
Thank you. The next item that we have is, somebody could please stand for the Pledge of Allegiance. Flag.
North that way.
I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The next item we have is consideration of the approval of the minutes of March 21st meeting. We have a few minutes to look through. Do we have it? Do we have it?
They are separate.
They're separate. Okay. So, you good? We have a motion for approval? So moved. We have a motion, do we have a second? And a second. All those in favor?
Aye.
All those against? Motion carries, thank you. Do we have any citizen comments?
No citizen comments at this time.
Next item is public hearings. The next item that we have is a public hearing discussion in regard to the City of Laredo Land Development Code, Section 24-69, flood damage prevention by adding a statutory authorization and findings of fact sections, including the Texas Commission on Environmental Quality in Section 24.69.4-B6, updating the elevation requirements of service equipment in Section 24.69.5-A4, and revising section numbers. Okay, can you go ahead and Vanessa, give us a quick overview?
Absolutely. Just recently we had a certification review, a visit from the Texas Water Development Board, and through that process there was a number of findings, and one of them was that we should include this language in our floodplain ordinance. This language comes directly from through their recommendations to be added to our ordinance. It has just a tiny bit of amendments that we'd like to make, just a little bit of grammar cleanup. In the first paragraph, you see in the second line, instead of it says the delegated the responsibility of the local governmental units, that of should read to. And then in the third line, you'll see, therefore, the City of Laredo, and again, we just want to clean that up. Instead of Laredo again, we want to remove that and add a comma there. And that's basically the main thrust of the additions. We are adding in section 24.69 new enumeration 0.4, or rather 6, and that's located on page Roman numeral 464 of your packet. If you look at 6 under that section, you'll see that we've added the Texas Commission on Environmental Quality. And again, we have just a tiny bit of cleanup there. In the first line of that item, we'd like to remove the first and, where it says adjacent communities and, right? It should read adjacent communities, comma, the state coordinating agency, and then comma, Texas Water Development Board, TWDB, comma, and then the final revision should be the word, it says also, we'd like to remove that. The final revision is in section 24.69.7. And you'll see in red that we're adding the words 18 inches or more. And that's in order to make sure that we are elevating the air conditioning, heating, mechanical equipment 18 inches above base flood elevation. And with that is the entirety of the recommended changes that have come through the findings of that certification review. At this point, we just brought it forward for introduction, for you to review it, have some time to look at it. We'll bring it back at the next meeting for action.
Let me ask you a quick question.
Sure.
We're going to 18 inches above the BFE.
Mm-hmm.
We're at 12 right now? I thought we were at 18.
We're at 18.
So
But
we're just ascertaining the language, it's not in the ordinance.
Yeah.
It is on the ordinance. If you go to section, let's see, where is it? Under 24.69.5, section B, specific standard under residential construction, it does say 18 inches or more, elevated 18 inches or more.
Okay.
So we just need to add that language to that part.
So you're putting in 2 different or 3 different, adding it in. where-
Yeah, it would.
Where did he say it is, please?
It's on
For whatever reason, it wasn't added at this point.
IV 67.
24695?
IV 67 at the bottom of your.
Right, that's where it says 18 inches, but you made reference to something
Just
earlier.
right below it. A little bit further, the same page, right below it.
elevation.
Yeah.
18 inches else is on the next page also. Okay.
I mean, it's a standard that the city's been using for,
Since
8.
2008.
yeah, I was just about to say 8, so that's what I remember. So, yeah, okay.
And this is necessary because people have been circumventing it in some way or other?
No, we're just cleaning it up.
Oh, okay.
And we're adding some revisions that were recommended by the Texas Water Board.
This is also to stay in conjunction when they do a review of our flood insurance. Your ordinance must reflect that the city is doing every effort to prevent flooding. So the 18-inch BFE, our BFE that was established way back in 08 was because of an insurance. What is it? Every 4 years, or I forget how many. Every so many years, they come in and do a review of your ordinances to make sure that, when flood insurance is issued, that the city's doing everything they can to prevent flooding. And so it was in 08 that I remember that review got done, and that's when we made a modification.
Correct.
And it's been that 18 inches since then, and it's worked fairly good, except
Yes, it
for
has.
a couple of areas that I remember, but that was, man-made acts natural acts of God that, you couldn't handle. It was just one of those things.
This is, you require action on this?
No,
No.
not today. We'll
Okay.
bring it back in the next meeting for action.
Okay.
But the point is that there's really no substantive changes, right? It's just whatever,
No,
kind
not-
of whatever
not-
you were required under statute. and then
Exactly.
just, like, comment.
Yeah, they were just concerned that we had the statute, the authorizing language.
Okay. Moving right along. The next item that we have is review and consideration of the following master plans. Item 7A, review and consideration of Los Presidentes East Master Plan. The intent is residential and commercial. The purpose of the revision is to reconfigure phases and realign streets. 7A. All right,
Mr. Chairman, this applicant has requested this item be tabled.
table it.
Mm-hmm.
Move it. Is that be tabled?
We have a motion. Do we have a second? And a second. All those in favor?
Aye.
Motion carries. Thank you. The next item that we have is the review and reconsideration of the Kaledi Industrial Park Master Plan. The intent is industrial. The purpose of the revision is to create a billboard plat, which was previously included as a lot in Phase 1. Proposed action is approved subject to the following comments from planning and utilities.
There's no updates at this time.
No updates? So basically we're doing create a billboard plat.
I'm sorry, if I may
Go right ahead.
This is to allow a billboard?
Just to pull it out of the master plan and create it by
A
itself.
separate
Out
lot
of the
by
phase.
itself.
Out of the phase.
This is like the Lamar and whatever,
Oh.
that kind of billboard?
They're
Yeah, those
undoing
billboard
it.
plats.
Yeah.
They're taking it out.
Yeah.
Okay.
Yeah.
View to be included in the
Yes.
And that's because there's a prohibition now and they're going to remove it and delete it? Or
No, it's just they wanted it separate.
The way that if you look at the plat, it looked like they had two, and on an interstate highway.
Well, here's
I
the
think
deal.
they were too
The
close.
deal is this, if you're on a master plan and you don't take that out, the lot doesn't take any utilities. If you leave it in the master plan plat, they're gonna force you to utility. Okay? So it's, part of the reason is, you know, when you go to that smaller lot specifically for that, you're gonna be exempt from certain criteria in the planning process.
Okay.
Okay, so that's where that comes in, and that's how that makes a little bit more sense than if you leave it in the master plan. I think the little lot is right there. They're usually, what are they, about 10 by 10s or something like that? Or 10 by 6, it's like, yeah.
I make a motion to approve, close public hearing and approve subject, follow staff's recommendation, approve subject to the following comments.
Second.
We have a motion and a second. All those in favor?
Aye.
All those against? Motion carries. Thank you. Next item we have is preliminary consideration of Santa Cecilia Estate subdivision plat, the intent is residential. This is a 5.83 acre tract located south of Casa del Sol and west of Alo Verde Drive. The zoning is for 39 lots is R1A. The proposed action is approved, subject to the following comments from planning, from engineering, from water and utilities, and a notice to developer from planning. Any updates on this? No?
No, sir.
The engineer is Durant, who was it?
You're right.
Okay.
When we table last time?
Let me see.
No, with the Bernardo Ramos.
This is the one, yeah.
What item are we on?
8A.
8A?
Okay.
That's the one that was, yes.
Okay.
Mr. Chairman,
Yes.
the commission requested that legal be present at the next meeting. They aren't here, in case you have any.
Oh, okay. Didn't
Yes,
know.
I'm Sebastian from the legal department.
Okay, thank you.
I think the question we had the last time was, what is the effect of the lawsuit being filed? And I think that the answer was that there was no effect, but we just wanted to clarify that. And I don't know if you had some questions about that or.
Well, that was part of why we said,
Yeah.
y'all need to kind of go out there and flush it out, you know, I mean, the different parties involved.
Yeah.
Because the presentation and the information that was given to us by the engineering firm, if you guys remember, had a document that was presented to us
Like
that,
an easement or something.
yeah.
Well, we had two different presentations. We had this issue come up the last meeting with the engineering firm, but not the landowner. And then the
Right.
meeting prior, we had the landowner, but not the engineering firm.
Present the original master plan, but apparently was expired.
It was expired, but by them filing it before a certain date, they have certain vesting requirements and they're cutting off an easement. That's in short. So,
Well, essentially, the city doesn't enforce private restrictions, and from what I understand, the lawsuit is between. It's a private issue. Your all duty is to enforce the public restrictions and covenants, and for that reason, the separate private restrictions wouldn't have any effect on what you all approve for this matter.
Yeah, and I think we understood that the issue was that the engineer brought some easements for us to consider or review or something like that, and we were just like not sure if that was proper or not proper. You know, I mean, I guess that's what.
Especially there was some litigation or something that we're gonna.
They wanted
we
us
can
to-
be enjoined, we can be
I
added
think they wanted us
into
to
it.
act on the language from the agreement and the contract, or like the lawsuit, and they wanted us to take a decision into that, and that's where we were confused is to act on a legal document that has no bearing to the city, I guess.
Right, and that's why you wouldn't have to do that. That's a private issue. They would handle that in their own litigation. You all have your own duties to enforce for the public, and pursuant to those, you have to. There's certain statutory authority that you all have to follow, regardless of the private restrictions that are not part of the city.
So right now, the review by city staff and the proposed action to approve, it means that they've met all the conditions of the planning requirements. Okay, all preliminary, for the preliminary.
That's correct.
So they met also, by law, this body's duty is to approve if they meet all the conditions of the planning requirements.
Is that a yes?
Yes, yes. I mean,
That's
it's up to
our
you to
responsibility
do-
as a board.
Well, because the thing is, if they meet all requirements of
And
planning
we're-
and zoning, then we're obligated to approve it. Like, that's what he's asking.
At final. Right now, they're at preliminary. So, right
And then they have
now,
to go to
They're
one
not
stop
meeting
shop.
it because they still have a chance to sort it out.
yeah, they still haven't met it because they're in the middle of the process. So, but
All
we're
we're
saying
doing
you
right
approve
now
subject
is
to
we're
these
saying,
comments.
based on what they've submitted, preliminarily, this is a preliminary plat,
That's correct.
that this body, based on the recommendations by staff, can approve to go forth if they meet certain conditions to get to the final step.
So if we want, then we can add in planning note number 9 and say that they need to resolve any legal issue they have with the landowner behind them before they proceed.
I don't know about
I
that.
don't
Could they do
think
that?
so.
I don't think so because that's not part of the statute.
That's right.
That gives you all the authority to grant these.
Or
But
to
that
impose.
is only at the final stage.
That's only at the
At the final stage,
At
right.
at prelim, my understanding is at prelim, we have discretion to act or not to act. We can reject if we don't like the plat. That is whether it be for one reason or another. Take out this specific reason. Okay, in theory, if we don't like how the streets are connecting, if we don't like how something else or it doesn't fit in, the easy ones are that they don't have enough park space dedicated by statute. They don't meet the statute. Those are the easy ones. But we still have discretion to add in requirements to a plat at prelim. Once we get to final, like the ones that we have on items 9A through D and 10A and B, we have to approve as long as they meet everything else. It's a ministerial duty. But here we have discretion, correct or incorrect?
We have discretion to add comments, obviously, we add comments all the time. The nature of the comment, that they resolve a private issue, not sure about that one. I mean, I
Because
think
we
we'll
run
leave
into
that.
an issue that allowing them to cut off an easement is a taking of the other person, the property owner from behind who's come here before and said so for land use purposes. It's an easy taking. And by us going through with it, opens the door that we're gonna get hit. And because it's at prelim, they're going to move on to the next step of developing the property. At final, the actions have already been done. But when we're at prelim, my understanding is we have discretion to add in requirements or take out requirements depending on certain reasons.
My understanding is that they would need to be based on the ordinance in some frame or fashion.
Yeah, I think what you're saying is that in other words, if there is the universe of what you can put in the comments is limited to what the statute allows.
That's my understanding.
And what you're
But-
saying is that the requirement that the private landowner issues be resolved is outside of what the statute.
Can I
I,
read?
that's
Can I
my,
read?
I mean, I would defer to legal on that, but I mean,
Can I read planning note number 1? Identify. I'm going to read to you planning note number 1. Identify all easements on plat. We're already blocking an easement. The plat doesn't contain the easement that the other parties are complaining about. Do you see what I'm saying? Like we're putting notes in there that are already in conflict with what you're saying.
well, they're saying, my understanding is that they're saying that there aren't any easements.
There's no recorded easement, and the deed that he did provide the lawsuit and all that they did submit actually does not specify
The thing
that
is,
easement.
the plat that we received at the meeting prior, okay, which we received and it had a volume number and it had a page number, was not contained in the documents that were given to us the second meeting. Okay, not the last meeting we were at had documents that were different from the meeting that we received before. This was the problem we had when we had one party present at one meeting, and we had another party present at a second meeting, and they were missing vice versa. So my point is, we've received one side of the argument at one hearing, the other side of the argument at the other hearing. But the thing is, the documents, we can't pretend and act dumb that we didn't see the document that we received at the
There's
very
no
first
document
meeting.
that says there's a recorded easement. Donato Ramos did not submit it.
They presented us one with, the one that we received, the first one, the plat that was filed, that they, when they originally presented it, the excuse was it was out of date. Okay, that's what staff told us, that they did have one, but it's old. It was from 1995 or 1994. The master plan.
It's not a recorded easement. A master plan is not recorded.
The contract that they gave us when they sold the property from party A to party B had recorded, it was a
But
warranty
there's
deed
no
with,
easements on that one. Well, the easements that he's claiming, or not those, the easement is the aloe verde that goes down. That's the easement that is referred to
there
in
was
the
also
contract.
one to the left.
In the deed that he provided with the lawsuit, it refers to that exit, and it refers to 59 entrance, the 60-foot easement. The contract actually says, or the suit actually says that the reason they're moving forward is because they didn't ask Donato for permission for approval of the new signature.
Because they were cutting off an easement.
The whole reason is that he needs to approve it before P&Z does, not because he's cutting off easements. He just needs to approve that they cut it off. But there's
In order
no
for a
easement.
person to release an easement, they have to approve. You can't do it. That's how you do it. Okay, if you cut off an access point to a landlocked property, you have to have that person's approval. With
We
or
haven't
without.
received a recorded easement from Donato or from the engineer. The engineer provided a title search that shows no easement on Either way-
Let's just agree to disagree.
it. Either way,
Okay.
it's private.
Okay. All right.
Well, and I guess the second question is like, okay, I understand it's private, but then let's say, if we approve something or it continues, and then in the private sector, it is ruled opposite by a district judge or whatever like that. Now there's a court order, and we already gave a decision, or they already went forward a certain amount of steps. How do we now reverse that if we allowed them to continue, and now there's a court order saying party?
If we allow them, if we act in opposition of a private easement, is that what you're saying? And
Right.
and that's kind of the what we're hearing from our legal department, that there may be easement, possibly, but even if there is, we don't enforce them. It's not us. The city does not enforce private easements.
Right,
So,
and
and
we're
I
not
understand your
trying to-
concern, and I can only refer you to the legal department. That's what they're telling us. Private easements, it's not us, you know?
But
I just want to make sure that we're,
I understand.
we're protecting.
I mean,
And-
it'd be one thing if we didn't know what we were stepping into. Here, we've been told what we're stepping into. We've been advised what we're stepping into. And the part where I disagree is that the documents we received at not the last hearing, but the hearing before, were specific enough that referred to plats that merged two documents. And they specifically relate to documents that were recorded and gave everybody else notice to do so. And if it's not uncommon for people to do title searches that may or may not ignore
that'll miss an
or
easement. Yes, sir.
conveniently ignore
Depending
things
what
that
title company
don't
you
fit
go
along
to.
their lines. And I'm telling you, as somebody who went to law school, who does legal cases, who knows who is experienced in land use laws, when somebody's giving you advance warning, like, hey, there's problems with this, and then the other side, maybe it's time we just wait, not move on a plat that has issues, and put ourselves at stake where Ms. Castillon has to help us out because we stepped into something when we knew it was coming.
And I guess, to add that, like, I just feel like at some point when they're presenting the property at what point do we now question, do you have legal authority to make whatever suggestions that you want to do to your property? And because there is litigation, my question to both parties is like, do you actually have legal authority to make this presentation to the city to either cut off a easement that may or may not exist? And then we just approved it, and they didn't even have legal authority to actually move forward with their property. I guess that's my concern.
But see, the thing would be that all we can act on is what the city staff presents us. However, given the fact that we have other documents that were presented to this commission, the comment that you wanted to include, which I think is just a common sense approach to letting this thing go forward and saying,
Yes.
and the language would be something to the effect that all disputes or whatever you want to use as language get resolved to move it forward.
And I'm kind
I
of.
mean, would that be?
And it's not, because some of these are not the requirements we've approved, and the staff has recommended us putting questions in these comments before, which are not statute or required by statute. So the response that I'm getting from staff is a nonsensical response. That the only comments we can include here have to be authorized by statute.
Well,
I think I was.
Well, no, but they agree with
question
you,
is-
and that's a
Yeah,
nonsense. And I'm putting it mildly when that it's a nonsense response. We've had questions in here that had nothing to do with statute. We've had requirements,
I
including.
apologize. The questions that you've seen from traffic department, those are the ones that we see most often from traffic department. They're phrased badly. I totally agree that they should be phrased probably more formally as statements. And we have addressed that with them. But what they're trying to convey to the developer, to the applicant, is this is what we're looking at. To go ahead and check this, but it is based on their reading of the ordinance. The site distances must be X. Should they have written them in a fashion? Site distances shall be required X. Yes, I agree. But the questions are based on ordinance, not just their own wishes or desires.
But there is also a requirement of every public official that he or she upholds the laws of the state and the Constitution of the United
Correct.
States and the state. And one of the things that is illegal in the Texas Constitution is that we cannot take somebody's property without fair compensation or certain obligations. Here we're doing precisely that. And that's not in the statute, or that's not in the ordinance or whatever. And so what I'm saying is, if we can, there are certain things, if we already know that there's a problem staring at us in the face, I'm just asking we put an additional comment, and staff is telling me, no, we can't.
I'm not saying no, you can't. I'm saying I'm deferring to legal department. I'm not the legal
What's the
authority
comment
on
on?
that.
Just
That
that
whether
they-
you can
clarify
require.
whatever, deal with whatever
I don't think
easements,
that comments out of character. I
and
think what
that's
is-
it. And so.
So are we to ignore the documents that were presented to us the first and the second meeting, the easements? They were recorded, right? Are we to ignore those documents then?
I don't think you're to ignore them, no.
That's what you're asking us to do.
Well, no, I thought they were saying that they're actually not recorded.
Well, that's
I
her
saw-
interpretation.
we saw-
And that was the engineer's interpretation. But the thing is, the engineer showed up at one meeting after the attorney showed up at another one, and the file set that they had, they're recorded.
Yeah, they recorded that volume.
And things miss. Things get
and
missed.
they didn't do the brief.
Can't they verify? Can't you?
We haven't had anything submitted to us.
They don't independently go and
No, they don't do the research. They don't do the searches. It's whatever's presented to them, so they're gonna take it.
But if Joey's concerned about that it exists, but it's not being checked, shouldn't we just direct them to check it? I'm just saying. I mean,
Well, I think
why would
that's
we-
why
why
he
would we
wanted
guess
to
it?
add the additional comment, which pretty much would clarify it.
like just deal with it.
That's it.
Before,
That's all you're
before
saying is
final. Like
deal with it. I don't think your comment's out of character, to be honest.
no,
with
it
you.
would be a lot more formal than just saying deal with it. But
Well, no, I mean, you're gonna put it in, in some kind of formal language here that we
Yeah.
can add.
Could we just add to the first planning, number one?
identify and clarify the
Can-
existence.
can-
of-
can-
That's right.
Yeah,
Give them directions
can
to
we-
dig in and research it and bring it back.
Within
Legal.
from the middle.
Could
Whatever-
we
whatever.
modify
Yeah.
planning comment
Comment
one which says identify all easements on plat and clarify any disputes over easements.
Our easement that we are talking about is there's no easements on the actual lots, not that there is an active easement missing. That's not what we're referring to.
The thing is.
No, I understand that, but what we're saying is, okay, I don't know that we're saying this. I'm trying to reconcile what everyone is saying. What I'm asking is it possible to include, okay, I guess because the issue is, and I don't know that I fully understand, but I'm going to try. I guess the issue is that there is competing interpretations about the limitations on what can be done on that property based on easements. And you're saying that's a private matter that doesn't matter whether there is or there isn't.
That is our understanding.
That's your understanding.
From what the
He's
legal
saying,
tells us.
he's saying, well, not so fast. This lawsuit and the presentations that have come before us before are saying that it's something that we have to consider. That's what he's saying, right?
Well, okay. When we were
Yeah, I wasn't there, but I'm here now.
at meeting one,
Yeah.
okay, this plat comes in.
Yeah.
The applicant says there's no easements.
Yeah.
Meeting one, landowner from behind says. Landowner from behind says, by the way, there is an easement. I'm going to show you my warranty deed with the restrictions and covenants, which in that contract it points out to a plat that they did when they originally developed the land. And because of that, this plat is not in conformity with the restrictions and covenants that are in this.
So let me put
that are going there.
that. So what you're saying is that you want to have that clarified before you make a decision.
Exactly.
And you're asking for a comment to clarify that.
But the thing is, where they're correct is meeting two, applicant says there's no easement, ignores and denies the existence of the documents presented to us
Yeah.
at meeting one,
Right.
saying none of that shows up.
Right.
And so what they're correct in saying is their plat doesn't recognize the documents that were shown
Yeah.
to us in meeting one.
Yeah.
And so how do we bring those into play
Right.
when applicant
Yeah.
ignores their
Yeah.
existence?
The applicant was the one who presented us with
Yeah,
those
so,
documents.
so I think the compromise is, so that we have a compromise and we can move forward and approve what we have to approve today, is to just modify that comment to add some language as to, I guess would be clarification as to the easements that are on the property, the existing easements that are either in dispute or not in dispute on the property. And so we can approve that with that additional comment, and then they can continue to proceed with whatever they're doing, and then they can have the opportunity to provide more information as to what easements are there or not. Right? That's what you're saying. So
That's what I'm trying to say.
So that way we can
But we're-
approve what they need, but get more clarification on the easement conflict.
But we have to word it a little more carefully, because right now we have an applicant who ignores the existence of
A potential easement.
the potential easement. Yes.
So what would be your proposed language to item one?
But
Can we have it as a separate
Yeah,
item, because this item is not regarding to
Okay.
that easement that you're talking about.
Alright, so then back to item 9.
no, I'm really saying that his drawing isn't proof of a plat with a restriction as part of the contract of this when he sold the property, right?
No, when they sold the property, it was subject to the plat itself. Because the way that this plat came the first time, that street going south,
This way?
Well-
Oh, this way.
that street going south didn't
Deleted?
exist either. So when they came in, they added in the street going south, but they still cut out the street going
Right, but that's because fire department required that.
When they
Yeah.
initially came in, it wasn't for a plat, it was for the revision to the master plan,
Yeah.
or a new master plan. It's
Yeah.
at the second meeting when they came up with a plat.
Yes.
I'm really saying that it has to, if somebody draws something, because I've bought land and there's drawings on it,
Yeah.
but it's not there's no legal obligation to adhere to it, because it's just somebody's thought of how they'd like it to look. So you're saying, because I don't remember, I was there for the Donato Ramos part.
Yeah.
You're saying that was that's a contractual obligation, that when he transferred the ownership of the land through the sale, the new landowner accepts the responsibility of having to honor that street?
In the warranty deed with the restrictions, it puts it in there. It
Oh,
refers
okay, well
to
then
the
did we
plat.
see that?
Yeah, we saw it in
That's
the
all.
first. We saw it in the
No,
first
but
meeting.
I know that we saw his drawing, but was it your all?
we saw the
We
record.
didn't see what he passed out.
Yeah,
But I
we
guess
got a copy of
it's
it.
our,
Yeah.
No, but I'm just saying though that whatever nomenclature is a page and file
Yes,
or whatever, that's all official.
Mr. Ramos didn't hand them
Oh,
the warranty
we got it.
deeds, he gave it to us.
We got it.
okay, then you all should confirm if those are accurate and
But
legal.
at the same time, I guess we go back to the same disagreement, right? Whether there are or
It's
there
private.
aren't.
You're saying it's private.
It's a private matter.
And we really don't
that's-
have the authority to force it to go forward.
That's what
Is
we're-
that
Yeah,
saying?
I-
but I don't think
Indirectly, we
I
could
don't-
be
I-
taking-
But I don't think Commissioner Diaz is saying that he wants to enforce someone's easement. That's not what he's saying. He's not saying
He's saying
let's
check it.
deny the plat because it's messing with someone's proposed.
No, I wasn't
petition.
saying anything
What
like
he's
that. I
saying
was
is
just
simply
trying to-
what he's simply saying is once we come to a final decision later down the road, he wants to have the issue clarified so that way he knows that it's
Well,
either been determined that easement exists or doesn't.
That's exactly what he
But that's not
wants to
going to
do.
affect what he's going to vote as a commissioner or what.
no, all he's doing is putting the engineer of record on notice
Yeah.
that there has to be,
resolve this
A
issue.
resolution.
yeah,
legal.
a resolution, that's all he's
No,
doing.
no, clarification or confirmation. Yeah.
Okay,
Like, that's it, or I guess.
I think you don't want
I guess
resolution, you want confirmation.
I make a motion to approve, subject to the following comments, adding in planning note number 9, that applicant must provide clarification and confirmation that there regarding any easement issues
That are-
may or may not be attached to the property.
that's it.
Like,
Okay,
A second.
a second. All those in favor, or any discussion before I go further?
Well, one last thing.
All right.
So this fellow here that owns, or whoever the fellow or fella, they sued who?
no, Donato Ramos sued
Them.
Velo to enforce.
The
The
provisions of when they
yeah.
sold the land. Shouldn't we
And-
just let
and
the court finish that off?
Excuse me?
Shouldn't the court just finish that off and then we take action?
No, because see, the thing is that's in other words, that's why the city attorney is saying that's a private easement
We-
issue.
we can't go that far.
Even if the easement does exist, and Donato Ramos' rights are being violated, it's not it's not within our scope to be able to stop the development or the plat because of that. What he's simply asking for is just to have clarity as to this one point, so that when we do take the vote, there isn't any doubt as to what easement is there or not there. But not that he is gonna either not approve or approve in order to enforce that easement right. That's outside of our scope, of our ability.
Okay, but we could take no action. That's within our scope and our ability, right?
Now?
I'm
Or-
not trying to
Well,
be
we could always
I'm pretty
table
saying
it.
that.
I mean, theoretically, we could always table it and table it to
That's right.
infinity until
Yeah,
we get one.
but the standard
But-
is like that we're being
but-
capricious, like
yeah,
we're not really
we're-
following the
we're-
law,
we're-
like that.
we could get it issued.
We wouldn't want to do that. No, there's guiding principles that guide the commission, and if something
Like
has come,
intelligent decision making.
yeah. if there is no legal basis for denying the plat or for not voting on the plat, then we
And-
make then we're wrong.
And the
to not do
protection
it.
and the protection of a private interest is not enough to give us. To give us,
It's
but
not-
we have to do something to protect what we're doing because we know that there's a possibility that we are stepping on a private interest, and it's an actionable interest, and the landowner has already taken affirmative steps to protect their interest. So we at prelim we can do something to say that we need.
All right.
I think
And
we're
the
good.
fire department's been satisfied with this new exit to the south?
Yeah, we have the
Because
two
last time
exits
there was
we
just
need.
one, right?
Right.
This is very long.
Okay. I got a motion on the floor, do I have a second? And a second, all those in favor?
Aye.
Motion carries, thank you. The next item that we have is the final consideration of the Plan San Isidro Southwest. I think we have several, y'all wanna take?
Make a motion
Can I
to
just make
hear-
sure that I don't have a conflict?
Well, make a motion to hear items 9A, B, C, and D, and items 10A and B as one item.
Second.
Motion is second, all those in favor?
Hold on. Oh yeah.
You can abstain, we have 5.
No, that's fine. Go ahead.
Okay, all those in favor?
Aye.
Aye, all right, now we have,
Make a motion to approve said items that were just motioned to be heard as one item.
9A, B, C, D, 10A, B?
Yes.
they're all approved.
Second.
Second, all those in favor?
Aye.
All those
Motion to
opposed?
adjourn.
Motion carries.
Second. To adjourn.
Adjourn, all those in favor?
Aye.
Motion carries.
Just real quick.
Oh, yeah.
This